Back in January, when 5 black teenagers were accused of raping a girl in a Brownsville, Brooklyn park, the story made headlines in every New York paper. Now, those charges were eventually dropped, but the guys accused could still be haunted by this case for decades. A recent op-ed in the New York Times explains how New York has some unique laws that the author says fail to protect people accused of crimes. Yesterday, I spoke with the woman who wrote that article and was also on the defense team. Debbie Silberman is a public defender at Brooklyn Defender Services. Debbie, in your Times op-ed, you wrote that you were upset with 2 systemic issues that came up during your defense of a teenage suspect in the Brooklyn gang rape case, a case that we want to point out fell apart very soon after the arrest of the 5 teenage suspects. Those 2 issues were the release of the names of the underage suspects and the discovery laws that you say prevent defendants from seeing important evidence before the trial. Now, we'll drill down on both of those, but those are essentially the arguments that you were making in the op-ed?
That's essentially correct. We've got 2 very serious issues that came to light as a result of this case. The fact that my client's name is now out in the public sphere and it can never be taken back, even though this case has been dismissed, and the fact that no discovery as a result of New York's archaic discovery laws was ever turned over to me during the pendency of this case.
So let's start with the release of the names of the underage suspects who we should point out were charged initially as adults. What's wrong with releasing their names, and what impact will that now have for your client going forward now that he's been cleared?
Well, I'll start with the impact, and that's namely the fact that this is an individual whose name is going to be out there closely associated and tied to accusations, and really were very, very atrocious accusations. And there are collateral consequences that unfortunately will follow him for the rest of his life. Every time he applies for a job, every time he applies for school, any time that he has to interact with anyone, one quick search on the internet and his name's going to come up having tied to these accusations. And the second matter in regard to the discovery laws is, as I stated, namely the fact that clearly, as you stated, this case fell apart very, very quickly. I mean, within a couple of days, the initial accusations that came out slowly began to fall apart. And yet I never saw a single police report or anything in regard to this case. One fact that was not reported widely, if anywhere, was the fact that my client and the other individuals who were arrested were put into lineups, and not a single one of them was identified in a lineup as having been involved in this case and with this accusation. And I never saw any police report related to that fact, which is pretty serious.
And we'll get back to the discovery laws in just a second, but I have some questions on releasing the names of the suspect. First of all, on ages, at what age should names be released? If you've got an adult suspect, should there be restrictions on that? Or in the case of your client, when they're charged as an adult, shouldn't that information be released since we're treating them in the justice system as adults?
Well, there are 2 factors here. One is, in general, should there be a policy in general of anyone's name being released? And there are serious considerations and concerns with that. There are places, notably in Europe, where names are not released into the public before someone is actually convicted. I mean, we have to remember that we operate in a system where someone is presumed innocent until proven guilty. And yet when someone's name is put out there, we're already putting an onus on that person and a burden on that person to try and explain, to try and prove their innocence. And that's just simply not how our system works. In regard to adolescents, adolescents are treated normally in our system in a different category than adults, as they should be. There's so much science out there that explains how adolescents' brains are not formed into their early 20s, and they make decisions that they probably wouldn't otherwise as adults. And we certainly want to be treating adolescents differently than we do with adults. So while I would push for a system that didn't release any names until a conviction, adolescents are in a different category and should be treated as such.
But Debbie, what about the public's right to know? And that's on 2 fronts. One, because it's the state that's accusing, on everybody's behalf, accusing an individual of a crime. So don't we have the right to know there? And wouldn't the neighbors of somebody who's accused of a crime have a right to know that a neighbor of theirs has been accused of a crime, particularly a heinous crime like this?
Well, those are 2 questions. Addressing the first question as to does the public have a right to know, there is a greater and a much more significant public interest in protecting those accused of crimes. And the greater public interest lies in the fact that, as I stated, all of our clients are presumed innocent until and unless the prosecution can prove otherwise. And that presumption of innocence needs to play a larger and more significant role than almost anything else. And in regard to the second question about whether a neighbor has a right to know, I would put forth the same thing. I mean, we have a situation where statements, very public statements, were being made about these boys and about the Brownsville community. These boys were members of that Brownsville community, and the Brownsville community and our community at large let those boys down.
And you think that that should apply regardless of the severity of the crime that somebody is being accused of, murder, treason, rape, something like that?
Well, look at this case. This case is a perfect example where the allegations here were extraordinarily serious and extraordinarily egregious. And yet, when the truth came to light, it came to show that these boys were not guilty of any crime, and yet their names have now been out there. And I think this case clearly shows how important it is to have laws to protect their names and their anonymity when, in fact, no crime was committed.
Now, on to the discovery laws, and that's the information that you and other lawyers need to properly defend a suspect. What is the legal standard in New York, and when should you get all that information compared to when you actually do get it?
I think that all criminal defense attorneys should be getting that information as soon as it comes to light, as soon as the prosecution have it. There are states such as Massachusetts where they get those arrest reports at someone's criminal court arraignment. We have clients who have cases that are pending for 2 years, and for 2 years they still haven't heard some of the basic allegations and are unaware of the strength of the allegation that the government has against them. And that's something that does need to change. I mean, consider having a case against you for 2 years and not knowing some of the basic information, not having seen an arrest report. And that information should be given to defense attorneys very early on. As soon as that information is provided to the prosecutor, it should be turned over.
In this Brownsville case, you said that some of the evidence or lack of evidence that police had would have cleared your suspect, but the charges were dropped. So couldn't I make the argument that the system really did work in the case of your suspect?
No, because if the system worked, he wouldn't have been arrested in the first place. Had the system worked, this is a case which we know now that had it been thoroughly investigated before an arrest was made, we wouldn't be sitting here having this discussion. That's how an example of how the system would have worked.
And if you had had that evidence sooner, I mean, it's still on the prosecutors to do with what they will, to either prosecute the case or drop the charges. Do you think the case would have been dropped any sooner? How would your client have benefited if you had had that information sooner?
While my client's case was very public, I think that that pressure is why his case was dismissed so early. Unfortunately, we have 45,000 other clients per year, and so many of them are faced in very similar situations where there are complainants that are not cooperative. There's exculpatory information that needs to be turned over, exculpatory information which really challenges the prosecution's case against our clients. And if that information is turned over sooner, you know, we wouldn't have our clients waiting for justice and waiting for an answer for so long.
Debbie Silberman, attorney, public defender with Brooklyn Defender Services. Debbie, thank you so much for a few minutes.
Thank you so much for having me.
Up next, our Hudson Valley headlines. Stay with us.